Good afternoon, everyone. Thank you for joining us today for today's online talk, which will be starting at 3 p.m. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us today for today's online talk, which is entitled Copyright Notifications and Infringements. My name is Jasmine and I'm a pupil in Chambers with MWKA Associates, and I will be your moderator for today's session. Before we start today's talk, let me just introduce the firm and what we do. Our able team today comprises of 28 lawyers and a support staff of 21 strong. Dato' MWKA is today a consultant with the firm, following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small-medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, which includes litigation, adjudication, and arbitration. We also have a dedicated employment or industrial relations team and a department that is focused on servicing the needs of both individuals and families. Our practice group indicates some of our focus areas, which are supported by talents from both our corporate and dispute resolution team. Today's talk is part of our MWKA online talk series. By way of background, we have actually been organizing monthly lunch talks at our office since 2013, some of which they were also broadcasted live. But with the COVID-19 MCO, we have currently moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for our clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event that you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. So just by way of introduction, we have two speakers for today. Let me introduce to you Hannah Patrick. She's a senior associate in our dispute resolution department, and she was admitted to the High Court of Malaya in 2013 and then to the High Court of Sabah and Sarawak in 2017. So Hannah's practice areas generally are in general litigation, construction law, debt recovery, corporate litigation, and intellectual property. For our next speaker, that would be Carolyn Ng. She's an associate in our dispute resolution department. She was admitted to the High Court of Malaya in March 2022, and Carolyn practices in the areas of general litigation, intellectual property, employment disputes, and strata management. At the end of this talk, we will be having a Q&A session. So if you have any questions, please do not forget to type it up in the Zoom's Q&A chat box. Okay? And our speakers will address your questions accordingly. So for our top points today, we will have introduction to the Copyright Act 1978, as well as the copyright notification process, which will be done by Carolyn, and then copyright for your business and some case studies on copyright infringement, which will be taken by Hannah. So I give to you, Carolyn.
Okay, thank you so much, Jasmine. Good afternoon, everybody. My name is Carolyn. As mentioned earlier, today I'll be introducing all of you to the Copyright Act 1987, as well as going through the voluntary notification process. First of all, since this is the basics of Copyright Act, I'll just briefly explain what is copyright. So broadly speaking, copyright simply means exclusive rights to creative works. So if I have a creative work, if I wrote a book or I wrote a song, I would have exclusive rights over it. The main example, however, that I will be using today is this painting. Oh, okay, the green screen ruins it. But I have this painting here to be used as an example of creative work. And because I painted it myself, I have exclusive rights over it. It's just the simple way of explaining it. Now, if we look on this slide, we can see what is covered when we say creative works. Everything on this list here is pretty straightforward. Think of a book, a musical, a painting, a movie, a recording, or even a broadcast. For the final thing on this list is derivative works. And I think that will require a little bit more explanation. But before I explain to you what a derivative work is, I thought we could make this slightly more interactive. And for this, I have actually asked my colleague Hannah to assist me. But what I have here on the next slide is a QR code. So if all of you could just whip out your phone cameras and just scan the QR code, I will give you about 30 seconds because it does take you to a YouTube link, and I think that will take you a while. This is just an example of derivative work. So I think Hannah can just give me a thumbs up when all is loaded. Wonderful. Okay, so if you're somehow unable to scan the QR code for whatever reason, this link, it will actually lead you to a YouTube video of a popular song that was released by an artist called Young Gravy, where the first 8 seconds of the song is taken from the popular song Never Gonna Give You Up by Rick Astley. This is called sampling, where we use one piece of copyright work in another copyrighted work. This, of course, will have to be done with the permission of the owner of the original work. So that is briefly what derivative work means. So it is important to note that copyright actually exists automatically. There is no need for registration. There is no need, for example, with trademark, which we've had talks on before, you would need to register and make sure that you have the proper rights over it. But copyright exists the moment the creative work comes into existence. But there are a few simple requirements that need to be satisfied. So this has been covered by the Act. You need to show that sufficient effort has been expended to make the work original in character, and it has to be written down, recorded, or otherwise reduced into a material form. Sufficient effort here looks into time, labor, and skill. For the painting that I showed all of you guys just now, even though the green screen ruins it, I promise it looks good. And sufficient time, effort, and skill has been expended in making that original. These terms should not be confused with newness or novelty. That's not a relevant consideration. For example, back again to the painting, that was based on an original painting, an original copyrighted work that already existed. But you must show, like I said, time, labor, and skill to make it different, to make it original, to make it your own. Based on the requirements, we can see what would not be covered, such as an idea, procedure, method of operation, mathematical concept. All this means is that if I have an idea, for example, the plot of a book or a movie, and someone releases a book or a movie with the exact same idea that I had, I cannot claim copyright over it just because I had the same idea, unless I had written it down somewhere and I can somehow prove that I had that idea before the other person did. The Act further provides for the duration of copyright. So from here, we can see literary, musical, artistic works. The copyright lasts for the duration of the artist's lifetime, and an additional 50 years after that. So the beneficiaries will be able to claim copyright over the art, over the creative work. So for example, with painting, for the duration of my lifetime, I will have copyright over it. And when the lifetime is over, there'll be an additional 50 years after that, where it will still be protected. For sound recordings and films, it is 50 years from the publishing of the work. And it's actually 50 years beginning of the calendar year following the year of fixation. So for example, if I publish a sound recording this year, starting from that time that I published it for 50 years, it will be copyrighted. But if I never publish the work, if I just reduce it into a material form, if I just record the sound recording from the date, from the beginning of the calendar year, so 2022, that's when the 50 years will begin. Similarly with broadcast as well, 50 years from the year of broadcasting. So moving into the kind of protection that is actually afforded, what can you actually do with copyright? We will be exploring the three that are listed here in detail. First, and the most obvious, is legal rights. This includes being able to enforce your rights against anyone who infringes your copyright. You have exclusive right to control. This applies to both direct and indirect copying. Direct copying is pretty straightforward, but indirect copying is, to give you an example, if I had the painting just now, and I say to Hannah, I permit you to, I give you my copyright, so you're able to use my painting, you're able to sell it, distribute it, whatever it is you want to do with it, you can do with it. But Jasmine copies off of Hannah's painting. That is called indirect copying. So she is not copying from my original work, but she's copying from a copy of my original work. Next is economic rights. Simply just means that I can get money off my copyright. I can reproduce it, I can perform it, I can distribute it, sell it, any form of commercial exploitation. I have commercial rights to my creative work that I have copyright over. Licensing here is covered under Section 27, and it is where it just explains that copyright is transferable. But in order for the copyright to be transferable, it needs to be in writing. So using back the example just now where I said Hannah is able to make copies of my painting and sell them. This would have to be in writing. It would need to be in writing, if not, it doesn't count. And let's say if I own the painting jointly with somebody else, the fees that we get from the licensing will be split equally between two of us, unless there is an agreement that I will get 100% of it or 80% of it, so on and so forth. Finally, an author has moral rights. There are actually two kinds of rights that are covered under moral rights. The first one is paternity rights, and the second is integrity rights. Paternity rights is my ability to claim ownership. So to say that I own this creative work and it is mine. And integrity rights is to object to any distortion or mutilation of the work. There is a test here to be proven, which is that it must be considered to significantly alter the work in a way which affects the author's honor or reputation. To give you an example of this, let's say I produce a song, or I have a sound recording of any sort, and Jasmine infringes on my copyright. She takes the sound recording and she distorts it or mutilates it to maybe say something offensive or just change the character of it, and in a way that will reflect badly on me as the author. That would also be an available option because I have copyright over the original work and no one is supposed to even be able to copy it, let alone distort it. In deciding this, in that case, I have the right to object to it. I have the right to start a legal suit against her, or rather just even if it's just writing a letter of demand to cease and desist. In fulfilling this test, the court has consideration of the views of the author. Of course, affecting the author's honor and reputation is something that is very subjective. What might offend me might not offend someone else, and vice versa. So the important consideration here is, of course, the author's feelings or views on whether their honor or reputation is disturbed. Finally, in a very broad view of the Copyright Act, we have to look at infringement. Later on, Hannah will be explaining further into infringement as well as going through the case studies with us. But just very broadly here, in proving infringement, the court will look into the similarity between two works and whether it can be said that the infringing work is sourced from the original work. So it has to be sufficiently similar. Once again, this is a very subjective test. Infringement also covers not just copying, it also covers selling, offering to sell, distributing, possession of contrivance. So what that means is if I possess machinery which has the ability to infringe on my copyright, making copies of it. Now that we understand the basics of the Copyright Act, we can look into the copyright notification process. To start off, we need to understand that there is, like I mentioned at the beginning of my talk, that there is no proper registration of copyright. There is no even proper need for it. It exists automatically. The moment this painting was reduced into a material form, I had copyright over it already. However, if someone copies my painting now and decides to sell it, I look at it and I say that's very unjust because evidently I owned or I had something similar first and I own copyright over it. If I start a legal suit and I bring it to court, at court, I will have to prove that I painted it first, that this work is based on my work. But what if there is nothing to show that my work existed first? Because as we remember, copyright starts from the time that it is reduced into a material form. If there is nothing to show that my creative work was reduced to a material form first, then it would be more difficult to prove my case to say that this infringing work is a copy of mine. While that is very heavily simplifying the options, when I register my creative work with MIPO, then there is at least a record of it. So let's say today I decide to go through the process that I'm going to run through with all of you. There is a record, there is a copyright notification that this work was done by me at this date. And going back to the example just now, if someone decides to make copies of my work and start distributing, selling, if I bring a case against them, at least I can use the evidence that I registered it to say mine existed first. Like I mentioned just now, assist in providing evidence of ownership and the date of creation. It is submitted with Intellectual Property Corporation of Malaysia, and it is actually a fairly simple process with minimal charges involved. So what is needed in registering your copyright with MIPO? There is a form that you will need to fill up, Form CR1, along with a statutory declaration stating that you are indeed the author of creative work. An electronic copy of the work will also need to be submitted, and there are, like I mentioned earlier, there are fees involved. To submit it to MIPO, then there will be a copyright notification that will be issued to you. So this is what Form CR1 looks like. This is of course not the full form. The form extends to about 3 pages, asking for details on the applicant, the author, the owner, and the licensees. And here, following the Copyright Voluntary Notification Amendment Regulations 2022, provides for the fees for registering. Here, I have only taken a screenshot of the main fees involved. So notification of copyright, 200, additional fee, and administration fee. But of course, this also further extends for about a page. You can find it at the link that I have put here, where it also provides the more extensive fees for amendments and notification. Just briefly speaking of the process, after you submit the necessary, MIPO will record the notification in the Register of Copyright and they will notify the applicant. So me and my painting, I fill out Form CR1, I sign a statutory declaration saying that I am indeed author, creator, artist of this painting. I pay the relevant fees and I reduce this into an electronic form so that I can submit it to MIPO. And once I have four of these things and it can be shown that no one else has something similar already registered, I will receive a copyright notification. Okay, so that is it for my portion on the Copyright Act as well as the voluntary notification process. I will now be passing off the time to Hannah to speak to us about copyright for your business and to go run through some case laws with us. Over to you, Hannah.
Thank you, Carolyn, for introducing to us the Copyright Act. I do hope one day you notify my peer of your brilliant painting, which I'm sure was quite beautiful. And good thing we didn't see, because now nobody can copy it. Yeah. All right, everyone, I will take you through 2 portions in this presentation. The first one being copyright for your business. I will take you through some basic benefits that you will receive if you have your copyright notified and how you can protect your copyright as well. And then later on, I will go into some also basic principles of infringement and then some of the more popular cases that have been reported. Now, as Carolyn has rightly pointed out, copyright is something that you can use commercially and can be licensed. You can get financial rewards from your copyright. All right. So notification gives you just this extra protection so that you can control its usage in the market. Now, what do I mean by this? It simply means that if you have it notified, it will give you some confidence to make it accessible to potential users. So for example, if you have a beautiful photo that you want to advertise, or you want to have people use or in their own materials, they would have to come to you, tell you like, hey, I want to use your photo. What are the payments necessary? Now, having your copyright notified would actually give you the confidence, as well as the person who uses your photo, the confidence that your photo is yours. It's original. You have taken that photo. You own the copyright to that photo, right? So having it notified, having your copyright notified offers legal protection when necessary and additional legal remedies to the owners in infringement claims. Now, in the unfortunate event, there is an infringement claim against you, or you have an infringement claim against someone, having a notification will help in the process of proving ownership. Okay. Now, according to the World Intellectual Property Organization, WIPO website, notification can help solve disputes over ownership or creation, as well as facilitate financial transactions, sales, and the assignment and or transfer of rights. I think that's pretty clear. Okay. All right. Other than notification, how else can you protect your copyright? The first, and I think this is the most basic thing that has to happen, is put up a copyright notice. If you have a website, have it there. This is an example taken from the MyIPO website. So you can see here, and I've taken it from their website, so the source is there as well. Any website that you have, any printed materials you have, for example, should have a copyright watermark or having your logo attached to any of your artwork or your photos or videos can be also a way or form of protecting your copyright. Now, to stop or to infringement claims, you can also use royalty-free photos for your website. Or again, take your own photos and then put a watermark. Now, the last and most, I think this one has stood the test of time, is sending your creation to yourself. Now, what I mean by this is, in the past, what people used to do is, if they have a literary work or artwork, what they do is they will put it in an envelope and post that document or that artwork to themselves to show that was the date that that work has been created. That was when copyright existed. Now, what you can do is, maybe you can do the same. You can post the thing to yourself, or you can have it emailed to yourself. But again, you don't have to take this step. What we have right now is a mechanism for you to notify MyIPO of your copyright. You don't have to do this. You can do that instead. Now, there was another thing that I think that would be relevant if you are a company or you're an employer, or if you are working under someone and you are tasked with, for example, creating, if you're a songwriter, for example, under an agency or a company, who owns the song? The company or the songwriter? Now, under the Copyright Act, the copyright is deemed to be transferred to the employer and to whoever who has commissioned the work. All right. Now, subject to any agreement between parties. So by default, the copyright is owned by the employer. However, you can talk to your employer, talk to your company, and include some kind of joint ownership arrangements in your contract. That would be the best. That would be the most fair way of protecting the ownership of your work. So now this also works not just to an employer-employee relationship. This also works in a case where someone commissions a work to you. So know your position in law and make the necessary arrangements where applicable. We now move on to the case studies on copyright infringement. Now, before I go into the actual cases, I will take you through some basic principles, legal principles of infringement. Okay. Now, there are two kinds of infringement, direct and indirect. And direct infringement is also, and then further divided into two. Number one, it is doing an act restricted by copyright without consent. The elements that need to be proven are these three: sufficient objective similarity, causal connection, and substantiality. Don't worry about the terms, I will explain them later. And then the second part of this is causing others to do an act restricted by copyright also constitutes direct infringement. Now, Section 36 of the Copyright Act merely sets out when and how a copyright is infringed. Now, it is defined by any person who does an act or which is controlled by the copyright under this act. So what is considered an act that is controlled by copyright under the act? I didn't list them down, but I will give an example. For example, in literary or musical works, the act that is controlled by the copyright is the reproduction of this work, the performance of this work, and the distribution of the media of this work. All right, these are the things that if someone has done it contrary or did not get your consent as the creation, can be seen as an act of infringement. We now go through the three elements of direct infringement. First, there is sufficient objective similarity. That means you look already, you can tell that there is similarity. Okay, that is something you can see visually or hear or feel. You are to compare similarities or differences between the products. Now, usually if this matter goes to court, the court will more often than not rely on expert witness to, an independent third-party expert witness to inform the court of the similarities and the differences. Now, if, however, what is considered similar is unoriginal, is a general idea, or it's considered commonplace. Now, these are phrases or words that have been used in case laws before. Now, if there are certain things, it's like everyone knows already. Now, if it's very unoriginal and it's general ideas, the court will say that the court will disregard that feature, that particular feature. Now, the next thing that the court will look at is the causal connection. Is there a connection between the infringer and the person or the author, and between the products as well, obviously? All right. What is the connection between these two? Were they former employees? Were they former distributors? Were they former license holders who continue using the artwork without the license? Things like that. Now, if you can establish certain facts like this, you can show causal connection between the infringer and the author. And what is important here also is that, is there a coincidence? Could there have been a situation where I didn't know that this copyright existed? Now, if the court is convinced that, there is no way someone from Malaysia and someone from the US, for example, wouldn't have had the opportunity to even meet. And if one day the US company decide to bring the product into Malaysia, and then who owns the copyright first in Malaysia? Remember, copyright is territorial in nature, so it only applies to our country in Malaysia. So if there is a claim of infringement, it's very important to show that, for example, if the US company comes to court and say, look, there is no way I would have known that there is a ready product in Malaysia that has the same thing. So there is no causal connection. And if there is no causal connection, the court may say, no infringement. Okay, so that's causal connection. And third and finally is substantiality. Now, substantiality is how much of the similarity is substantial. Now, substantial doesn't mean out of 5 words, I copy 4 words. It's not the quantity that the court looks at. The court will look at the quality. For example, if there is something that is very distinct from the original work that has been copied in the infringed work, if the feature is very prominent, that anyone who sees it can know that it's actually the original work, doesn't matter if it's just one, the court will say, look, the quality of this copy is substantial enough to say that you have copied the original work. Okay, I hope that is clear enough so that what exactly is. The court will look at all three must be proven before you can prove infringement. Okay, I will now go to 3 reported Malaysian cases. The first case is Honda. Honda is, if anyone here rides the motor, will know the EX5, the very classic EX5. Now, this has been a subject of an infringement claim before in Malaysia. So Honda sued this company called M-Force for infringement of artistic works of its motorcycle known as Honda EX5 and EX5 Dream. So what is considered artistic works here are the 2D drawings of the motorcycle and the actual 3D form of the bikes themselves. And the infringing motorcycle is called SYM E-Smart Motorcycle. Okay, now this case went up to appeal because the High Court decided there was no infringement. So Honda wasn't happy. Honda appealed to the Court of Appeal. So the Court of Appeal said that the artistic works of Honda is original. There is no way this SYM could have existed before Honda did. Okay, but what SYM said, however, is that my motorcycle is based on a Vietnamese motorcycle called Sanda Boss. So they're saying that because I copied off Sanda Boss, I didn't infringe Honda's copyright. So the court went through a long process to establish, or to agree rather, with the causal connection that was given by Honda. First of all, copying can be direct and indirect, as what Carolyn mentioned earlier. If you copy off a copy, that is good as infringing on the original form. Okay, and the court has also decided that both Sanda Boss and M-Force had prior access to Honda's works, meaning Honda's works was already in the market. If I'm not mistaken, the copyright for Honda works has been in the market since the 1990s, and SYM and Sanda Boss only came much later. So there is no way you can tell me that you have had no notice or you had no access to Honda's artistic works. It has already been in the market, and therefore us being in Malaysia, motorcycle is something quite common. There is no way you wouldn't know the EX5. And then the court also looked that there were design features that were similar between Sanda Boss and Honda. And then the court said that Sanda Boss is a copy or an almost identical copy of the EX5, and therefore a causal connection was established. So was SYM independently created? No. It was a copy of a copy, and which is also an identical copy. And therefore the appeal was allowed. The next case would be on computer software, Flexsoft and Technology and Sdn Bhd and First E format. Just a little bit of background. For some time, people weren't sure whether computer softwares would be afforded copyright protection. So this is a case where we will take a look at that. Okay, this is not the first case on, let me just point out, this is not the first case on copyright software, but it's one of a good example. Okay, Soft is the owner of a POS system called FlexiLite POS, and they sued a competitor for infringement, having discovered. So they did, I think they did an operation where they purchased the defendant's products, and then they realized that there were substantial similarities between the two softwares. So the court went on a deliberation on whether this POS system is eligible for copyright protection. And the court went on to say computer program is a literary work and therefore eligible for copyright protection. And in here, I don't have the photo, but if you read the actual case, you will see a chart that showed the software development process flow chart. Now, what's important is that copyright must be reduced into a material form. So what this developer did was he had diary entries of how he came with this software. How did he create? What was his thought process? when he came up with this software. And he even was able to show his development through a flow chart, and that was clearly shown in the case. I should have taken a photo of it. But yeah, so the flow chart was there, and the court was convinced that, hey, this person definitely owned this system. So the court again looked at objective similarity and causal connection. So was there objective similarity? The answer is yes. Even the defendant admitted that there were similarities in features, coding, interface, and functions. So under cross-examination, the lawyers must have done a very good job in getting the defendant to admit these similarities. And then the court, they were also able to show the causal connection between the plaintiff and the defendant, because the first defendant had access to FlexiLite POS software because they were the former distributor of the FlexiLite POS software. In this case, the court also allowed the claim, and the court said, yes, there was infringement. The third and final case is the case of Juris Technologies and another, and Fu Tianxin and others. This is the case on the employer and employee situation, which I described earlier. So here the defendants were the employees of Juris Technologies. They used confidential information from the plaintiff's software to build competing software programs. And they even set up a competing business while they were still in employment with Juris. Just a little bit more background. So when the company was set up, when the competing software program was already set up, one by one left the company. Okay, so one by one left the company to join that company that they had set up while in employment. So in this case, the court relied on expert opinion to see whether the softwares were objectively similar between each other. This case did go through a lot of other legal principles, breach of confidence, whether there was breach of confidentiality, sorry, not breach of confidence, breach of confidentiality. And the court said, yes, there was a breach of confidentiality. But keeping it within the infringement topic, this is what the court has decided. The sixth defendant, which is the new company, is an entity which has been incorporated and managed by the other defendants to commit the wrongs against the plaintiff. The first to fifth defendant had caused the sixth defendant, which is the company, to commit copyright infringement. And in the circumstances, the first and two-fifth defendants have also committed infringement, copyright infringement. Basically, all the defendants did. Okay, the claim was allowed, and to set an example, the court granted a lot of damages. There was exemplary, aggravated, and additional damages. What this means is this court granted damages means compensation in the form of money in very high amounts, just to set an example so that people don't do this. Okay, I thought it would be also interesting and for me to present to you some of the famous copyright infringement claims or actions out there in the news. And I think this is quite relevant to us because I don't know about you, but I don't know, within my circle, a lot of people have TV boxes. It can be of any brand. I have seen a lot of brands come up with their own TV boxes, and then sometimes it can be, they will intercept or take broadcasts from unlicensed content from any other countries. Now, I know it's good for us consumers because then we can enjoy content from a lot of places, but this is actually chargeable under the Copyright Act. Okay, so this is something you may want to take note of. There are actually two incidences that I've seen in the news. This is by Astro. The Astro put up this case, mounted this case. And finally, just for good measure, I thought of just also listening to you some famous international copyright infringement cases. And if you know the singers at Ed Sheeran and Taylor Swift, they have been themselves subject to copyright infringement claim. First would be the Shape of You song, very famous song, but he won this case, and so there was no infringement. And according to Ed Sheeran, he said there are so many material out there and there are only 12 notes of music. It's impossible for there not to be any similarity in terms of your tone and your melody. So that's what Ed Sheeran had said. And yeah, copyright a case of Taylor Swift, of also another famous song, Shake It Off. I think this is still underway. She has just filed her defense. And she's saying she has never heard of this song that they claim to have, she has infringed. And she has never heard of the group that claims she has infringed. So this is something you may want to Google later on. Okay, my final point would be on the remedies. If you are someone who, you are this copyright owner and you want to claim from the courts damages, and you want to know what else can you get from the court if you put in an infringement claim. So you can order for injunction simply means getting a court order to tell someone to stop using your copyright. Okay, you can get damages. Damages means amount that you can get in money, and statutory damages of not more than 25,000 ringgit for each work, but it has to even out to just 500,000, and any other order, whatever order you want to get. Or there's also an account of profits. So the Act allows you to get all these. So if you want to put in a claim for infringement, these are the things you can ask for. One more thing I did not have in slides is that there is a way for you to, other than going to the courts, you can actually file in a claim at the tribunal. The MyIPO has a tribunal where if you don't want to spend too much time and money using the court process, you can actually go via the tribunal. You can file a claim under the tribunal. You can go to the MyIPO website. They have very good step-by-step methods of you on how you can put in your claim. And with that, I am done with my presentation. Over to you, Jasmine.
All right. Okay, so now it's time for questions. So if anybody has a question, please drop them in the Q&A box. All right. So we have one question. And first of all, thank you, Hannah and Carolyn, for your insights on copyright notifications and infringements. So we'll now take questions from the participants. Please put them in the Q&A chat box. So the first question comes from Anonymous. It says, if I create a piece of work during the course of my employment, who holds the copyright over the work? So I will direct this to Hannah.
Yes. Okay, so as I mentioned earlier, the Act actually already says that it will be deemed to be transferred to the author's employer. So unless there is a separate arrangement between you and your employer on how you would like to have it distributed or arranged. So sometimes it can be a joint ownership situation, which I think is a more win-win situation. Or sometimes you can try to insist that you own the full copyright. Now, for this to happen, it'd be a bit hard, especially if you use the company's resources, for example, to create your work. Your creation is completely not related. For example, I'm in a law firm and I am creating a song. I'm writing a song. It's nothing to do with my employment. It's done outside my working hours. There is nothing that it will never come under the purview of my employment contract. So that's completely separate. But if I create something that is under the banner of my firm, then, and if I use the resources in my firm, then yes, some arrangement must be made prior so that there will be no disputes in the future. Yeah, I hope that answers your question.
Who can file the copyright notification? Must there be a license? So I believe I'll give this to Carolyn.
Yep. So actually, anyone who has a creation, like I mentioned just now, we went through the list of things that can be copyrighted, whether that be literary works, artistic works, musical works. So all of those things can be copyrighted by the owner of the copyright. So if I want to register my copyright for my painting, I will have to be the one to do it. And a license is not required here. A license would just be allowing someone else, me having an agreement with someone else to allow them to utilize the copyright, to be able to have economic rights over it, to sell or to use it, to distribute it.
Our next question comes from Kelvin Yong. He wants to know how much it costs to copyright.
Just now, during my presentation, I did show a scale that is actually given by MyIPO under the voluntary certification rules. And that provides for just the general fees that are involved. However, if you are interested in copywriting your work, you can feel free to drop us an inquiry and we can discuss further on the proposal of our fees in assisting you to copyright your creative works.
What about the sales and purchase agreement and other agreements drafted by a legal practitioner and blatantly copied by another? Can we file the agreement with my IPO?
Okay, I'll take that question. I'm not sure what SPA you're talking about. There are different kinds of SPA, but if you're talking about the SPA, for example, the sale and purchase of a house, that is actually part of a standard form under the Housing Development Act. So that's not really, all of us are copying the Housing Development Act and changing some details to suit our needs and our clients' needs. So in that sense, I don't think notification is necessary or can be done. But if you're talking about other kinds of agreements, other kinds of SPA, now if it's very distinctly, if you can show in court, again, now, if you want to know if it will stand in court, for example, can you prove for a substantial, the similarity, the objective similarity test? If you are able to show that your work is very distinct, it's original, only you would have used that phrase, for example, then I think, yes, it's worth having it notified within my PO. Otherwise, then if you don't think it creates that kind of value, then you may want to think twice about it. Yeah, but I will say this is an interesting question. I've never really thought about it. Some lawyers, as a person who drafts documents, definitely we all have our distinct style. But to call it original is something that it's a question mark in my books. Yeah, so I don't know if you have any additions to that, Carolyn. Otherwise, I think that question is answered.
Okay, so moving on, Hanno has a question. How will they quantify the claim amount?
I can answer that question. Okay, the claim amount really depends on mostly on how much you can prove would be your loss if the infringement continues to happen. So for example, if you are Ed Sheeran, and if his work is actually copyrighted, and if a lot of people copy his work and make money off of it, instead of listening to his song, I listen to the other works. What kind of loss would I have suffered as Ed Sheeran? I'm a big name. People know me. I'm a big celebrity. The worth of my work is a lot. This kind of quantification, if you can do, will be good for you to claim the amount that you want. Okay, but of course, these are things that you have to prove to court to show, because other than just infringement, sometimes the infringement is there. Or what is your actual loss? What is the loss that you have suffered? That is something that you may need to work out. Okay, I hope that answers your question.
All right, so unfortunately, that was the last question that we were going to take today, but no worries. If you have any further questions, you can feel free to direct your questions to our lawyers. Before we conclude, I would just like to make a few announcements. Everybody can see. So these are our upcoming talks, and I would be very grateful if you all would come see. So first, on the 7th of September, we have a software development talk, what to know about the new standard form contract by AIAC, which is the arbitration center. And on the 28th of September, we also have a talk on what to know if you're stopped for drunk driving or other road traffic offences. And secondly, please do fill our feedback form and please tell us what you thought about our talk. And the link to the form will be posted in the chat shortly. And thirdly, do follow our social media. We do post on there quite actively. So these are the links. I'll give you a moment to take a photo if you'd like to do that. And of course, to end, you may schedule a complimentary 30-minute either the video, or you could come physically as well, but it would be better to do it over telephone or video for your convenience and ours as well. It's a consultation with our lawyers, and you can fill out the form at the link provided here. I'll also give you a second to scan the QR code. Please fill in the form on our website. The link will also be posted in the chat box. So thank you to all our guests. Thank you for joining us. And we hope you have found today's session to be helpful and informative. So thank you, everybody, and we will see you at our next talk.